All right, welcome back to the podcast, everyone. If you caught our last episode, you'll remember we dove into the nuts and bolts of FAR and DFARS and how those frameworks shape contract negotiations. Today we're zeroing in on data protection, specifically how it's defined and handled in government contracts. Paul, Ruby, let's get into it. When we talk about data protection in the context of FAR and DFARS, what are we really talking about?
At its core, Eric, data protection in these contracts is about safeguarding sensitive information, whether it's controlled unclassified information, personally identifiable information, or even export-controlled data. The FAR and DFARS clauses lay out specific requirements for how this data should be handled, processed, and protected. But the devil's in the details, right? The contract has to spell out exactly what data is covered, who's responsible for what, and how those responsibilities flow down to subcontractors.
Yeah, and I think that's where things can get a bit messy. I remember this one negotiation, it must have been a couple years ago now, where the contract just said, the contractor will protect all sensitive data. That was it. No details on who was supposed to do what if there was a breach, or even what counted as sensitive. So when something actually did go wrong, everyone was pointing fingers. Is it your job? Is it mine? It was chaos. I mean, you've got to be specific, or you're just asking for trouble.
Absolutely, Ruby. And it's not just about the data itself, but also the scope of processing. Are you storing it, transmitting it, destroying it? Each of those has different implications under the clauses. Paul, do you see a lot of contracts where those roles and responsibilities are still unclear?
Unfortunately, yes. Even with all the guidance out there, I still see contracts that leave too much open to interpretation. That's risky for everyone involved. If you don't define who's responsible for breach notification, for example, you could end up with delays or even non-compliance. And that's not just a paperwork issue. It can have real operational and legal consequences.
And it's not just the big primes either. Smaller subcontractors sometimes get these flow-down clauses and don't realize what they're on the hook for. Suddenly, they're expected to have the same level of security as a Fortune 500, and no one's explained what that actually means for them day to day.
Right, and that's why nailing down those definitions and responsibilities up front is so critical. Otherwise, you're just setting yourself up for confusion, or worse, a compliance failure. So let's pivot a bit. We've talked about the US frameworks, but what about when you throw international laws into the mix? GDPR, for example, has been a real game changer for a lot of contractors. Paul, how do you see these regional laws impacting US government contracts?
It's a significant challenge, Eric. The GDPR, for instance, imposes strict requirements on how personal data is handled, even if the contractor is based in the US. If you're processing data from EU citizens, you're subject to those rules. That means you have to think about things like data minimization, consent, and the right to erasure, concepts that aren't always front and center in US federal contracts. And then there's the issue of international data transfers, which can get complicated fast.
Oh, totally. I had this contract review once. This was with a mid-sized federal contractor, and they were just blindsided by the GDPR requirements. They thought, we're working for the US government. Why would EU law apply? But because they were handling data from EU nationals, suddenly they had to rethink their entire compliance approach. It was a bit of a wake-up call, honestly.
Yeah, and it's not just GDPR. There are other regional laws, like the UK's data protection rules, or even state-level laws in the US, that can layer on additional requirements. It's a bit of a patchwork, and if you're not careful, you can end up with conflicting obligations. Paul, how do you advise clients to navigate that?
The key is to map out all the jurisdictions your data touches. You need to identify where your data subjects are, what laws apply, and then build your compliance program to meet the strictest standard. It's not easy, but it's better than getting caught out later. And as Ruby mentioned, sometimes contractors don't even realize they're subject to these laws until it's almost too late.
And that's where clear contract language comes in again. If you know you're dealing with international data, you've got to spell out those compliance obligations up front. Otherwise, you're just setting yourself up for a nasty surprise down the line.
All right, so let's get practical. Once you've got the legal framework sorted, how do you actually operationalize security and breach response in your contracts? Paul, what are the must-haves?
First, you need to clearly define the security measures you're committing to. things like encryption, access controls, and regular audits. The contract should also lay out exactly what happens if there's a breach, who notifies whom, how quickly, and what information needs to be shared. I've seen clauses that require notification within 72 hours, which can be a real scramble if you're not prepared.
Yeah, I remember reviewing a contract where the breach notification timeline was so tight, the team had to basically set up a 24/7 response just in case. It changed how they operated day to day. Suddenly, everyone was on high alert and they had to run drills to make sure they could actually meet that deadline. It was stressful, but it did force them to get their act together.
And it's not just about breach response, right? There's also the question of data subject rights, like access, rectification, and erasure. How do you make sure those are actually doable in practice?
You need clear procedures. If someone requests access to their data, you have to know exactly how to find it, verify their identity, and provide it securely. Same goes for correcting or deleting data. If your systems aren't set up for that, you're going to struggle to comply. That's why it's so important to think about these operational details before you sign the contract.
And sometimes the contract language is so strict, it forces both parties to up their game. I've seen cases where a really tough clause actually led to better security practices across the board. It's painful at first, but in the long run, it can be a good thing.
Yeah, it's all about turning those requirements into real, workable processes. All right, I think that's a good place to wrap up for today. Thanks, Paul. Ruby. Always a pleasure. And thanks to everyone listening. We'll be back soon with more on navigating the world of government contracts. Take care, everyone.
Cheers, Eric. Thanks, Paul. And thanks to everyone tuning in. Catch you next time.
Thank you both. Looking forward to our next discussion. Goodbye, everyone.